Aloha mai kako. Good morning, everyone. This is the June 19th, 2024, also known as Juneteenth. It's a federal holiday. Land Use Commission meeting. This is an in-person meeting which is being held at the University of Hawaii Maui College Student Lounge, Pilina, 310 West Kahumanu Avenue, Kahului, Hawaii, 96732. This meeting is open to the public. Court reporting transcriptions are being done from this Zoom meeting recording. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. And before speaking each time, please state your name and identify yourself and your affiliation for the record. So even though this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting. And it will be posted on YouTube and it will be used for court reporting purposes to record this event. If you do not wish to be part of the public record, you should exit the meeting now. I will also share with participants that we will be taking breaks from time to time, including a longer break for lunch. Typically every hour or so will take 5 minutes. My name is Dan Giovanni. I have the pleasure to serve as the LUC chair, and we currently have 8 seated commissioners. Along with me today are Commissioner Lee Ohigashi from Maui, Commissioner Michael Yamane from Kauai, Commissioner George Ata, Commissioner Mel Kahele, Commissioner Brian Lee from Oahu, Commissioner Nancy Carr-Smith from Hawaii Island. Commissioner Kamakela Ohelo is inbound from Oahu and will be joining this meeting in progress. Also in attendance are LUC Executive Officer Daniel Orendanker, LUC Chief Planner Scott Derrickson, LUC Staff Planner Martina Segura, and LUC Chief Clerk Ariana Kwan. A special aloha today to Ms. Miranda Steed, who is our LUC Attorney General. This is her first meeting of the LUC, so welcome. Before I proceed to the first agenda item, I'd like to also do an acknowledgement for the record that we lost a real super player yesterday, a gentleman by the name of Willie Mays. And I had the pleasure of seeing him play many wonderful baseball games for the San Francisco Giants, my team. So Willie, we're thinking of you and thanks for all you did to bring joy to our lives. Our first order of business is the adoption of minutes of the June 5th, 2024 meeting. Ms. Kwan, has there been any written testimony submitted on this June 5, 2024 minutes?
No, Mr. Chair.
Are there any members of the public who have signed up to testify on this agenda item?
No, Mr. Chair.
Commissioners, do I have someone who would wish to move to adopt the minutes?
Mr. Chair, I move to adopt.
That was Commissioner Ohigashi is moved. Do I have a second?
Mr. Chair, second.
Seconded by Commissioner Yamane. All in favor of adoption of the minutes, please indicate by saying aye.
Aye.
Any opposed? Hearing none, the minutes are adopted. Thank you. Our next order of business is the tentative meeting schedule. Mr. Orendanker, please proceed with your presentation.
Thank you, Mr. Chair. Tomorrow we will again be here for A11-792, the COM-DHHC status report. On July 10th, we will be on Oahu at the State Office Tower for Ethics Commission training. The 11th is currently open. On July 23rd and 24th, we will be having commissioner training, general commissioner training. That is, if you note, that's a Tuesday and a Wednesday, not a Thursday and a Friday, to accommodate the commissioner's schedules. On August 7th and 8th, we will be on Oahu at the airport to discuss Waimanalo Gulch, the special permit for Waimanalo Gulch sanitary landfill. On August 21st and 22nd, at a location that is still undetermined, we will be on Oahu to adopt the order for the Waimanalo Gulch sanitary landfill and to hear Makakilo Quarry on the 21st and the 22nd. We also may be scheduled having to hold a hearing on the 29th of August to adopt the order for Makakilo Quarry, and that is a result of the time constraints associated with the approval of special permits. We also tentatively have, in case we need them, the 30th of August and September 4th for Makakilo Quarry. We don't anticipate that we will need those, but we would ask the commissioners to be aware of those potential dates. On September 11th, 12th, and 13th, we will be on the Big Island for the Hawaii Conference of Planning Officials. On September 25th and 26th, we tentatively have scheduled the Mahi Solar special permit on Oahu. We also have October 9th and 10th tentatively scheduled for that. On October 23rd and 24th, on October 23rd, we will be taking up the A and B properties motion in A07772. And the 24th will be an Emmanuel Lutheran A07773 status report. And that takes us through November when the schedule becomes tentative again.
Thank you, Mr. Orendanker. Any commissioners, any questions or comments on the tentative schedule? Just one, are all of these meetings in person or is that still to be determined?
That's still to be determined. It depends on the adoption of order meetings may be virtual, but we're not sure yet.
Okay, thank you. So our fourth order of business is a status and progress report on SP 97-390 from the Department of Environmental Management, County of Maui, in response to a recently submitted 2023 annual report. Approximately 95,659 acres of land with a special permit for the development of recycling and diversion facilities. Will the parties please identify themselves for the record, starting with Maui County, please.
Good morning, Chair, Commissioners. My name is Andrew Nelson, Deputy Corporation Counsel for the County of Maui. On behalf of the Department of Environmental Management, which I'll refer to as DEM. Representing DEM today is Shane Agawa, Director, Mike Kihano, Solid Waste Division Chief, Sage Kiyonaga, Managing Engineer, Elaine Baker, Project Manager, and our planning consultant, Mark Roy of Munikio and Haraga.
Thank you. Let me just note that when these other participants will testify, we'll have to swear them in. So from the state.
Good morning. Allison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here is Aaron Sedogawa, from a planner from OPSD. Thank you.
Welcome. Back to the County of Maui from DPP.
Aloha, good morning, Chair. Good morning, Commissioners. Mimi Desjardins, Deputy Corporation Counsel. I am secondary to Mr. Nelson on this, but I'm also here with Kate Blystone, the Director of the Department of Planning. Thank you.
Yes, welcome. Good to see you again. So let me briefly explain our procedure for this item. First, I will ask my fellow commissioners if there are any conflicts of interest or disclosures that they wish to make. and then I will update the record. In fact, I'm going to do that right now. So fellow commissioners, do any of you have any conflicts of interest or disclosures that you would like to make regarding this agenda item? Seeing none, we'll proceed accordingly. Then next I will recognize written public testimony that has been submitted in this matter and identify the person or organizations who have submitted the testimony. Next, I will call on members of the public who wish to testify in this matter. Each member of the public will be granted 2 minutes to provide their testimony and should stand by after their testimony to respond to any questions by the parties or the commissioners. When all questions have been completed, the chair will excuse the witness and call the next witness. After completion of the public testimony portion of these proceedings, the chair would like the petitioners to provide their status report. The chair will then call on parties, that's OPSD from state and counties planning department, for their comment regarding the status report. The petitioners will then be allowed to respond to comments made by the county and state. Commissioners will then ask questions of the parties at the conclusion of each of their presentations. At the conclusion of the parties' testimony and commissioners' questions, the public will be again granted a second opportunity to provide public testimony in the same manner that it was set forth previously. Once public testimony concludes, the commission will enter deliberations regarding the status report to decide if any action is necessary. Again, I'm going to note that we'll be taking short breaks and a longer one for lunch, and that Commissioner Kamakela Ohelo will join us in progress. Does anybody have any questions on the procedure, starting with the petitioner?
No questions. Thank you.
Thank you, Mr. Nelson. The County of Maui, do you have any questions on the procedures?
No, thank you very much.
And state?
No questions, thank you.
Yeah, and please let me remind you that when you do speak, state your name. It just helps in the preparation of the transcripts. Also, in accordance with legal ethical standards, commissioners should disclose any of their relationships, business or social or otherwise. And I have confirmed that none have expressed any potential or prevailing conflicts of interest or disclosures. Please be informed that all relevant records and documents pertaining to this matter can be accessed for review on the Land Use Commission website at https://luc.hawaii.gov/SP97-390. Ms. Kwan, it's time for public testimony. Have anybody signed up for public testimony?
No, Mr. Chair.
Has there been any written testimony submitted on this matter?
We received one testimony from Department of Agriculture that has been posted to the website.
Thank you very much. It's now time for the status report. So Mr. Nelson, would you please give me an indication, an estimate of how much time you have for your prepared remarks?
Thank you, Chair. Andrew Nelson. Our presentation will be approximately 15 minutes.
Okay. Please proceed.
Okay, thank you, Chair. We are here to provide a status update on DEM's compliance with conditions 19, 21, and 23 of the LUC's DNO approving the Fourth Amendment to Special Use Permit for the operation of the Central Maui landfill, per the LUC's January 31st, 2024 letter request for this hearing. Now, before we consider each of the individual conditions, Our planning consultant, Mark Roy of Munikio and Hiraga, will provide a brief overview of the CML, its permitting history, and its layout and configuration. You'll find the presentation slides he refers to in Exhibit D to DEM's letter to the LUC, which we submitted on June 11th, and I believe is included in your meeting materials.
Is it Mr. Roy? Is that correct? Mr. Roy, please state your name for the record and affiliation, and then I'll swear you in.
Mark Roy with Munikio Hiraga,
How do you spell your last name?
ROY.
And do you swear your testimony you're about to give today will be the truth?
Yes, I do.
Please proceed.
Thank you. Good morning, Chair, members of the Commission. It's a pleasure to be here with you all today. My name is Mark Roy with the planning firm of Munikio Hiraga. The County of Maui Department of Environmental Management, DEM, has asked me to attend today to present a brief permitting background on the Central Maui landfill. Our company, Munikio Hiraga, has assisted with processing of certain special use permit applications for the landfill over the years, and we are also currently contracted to help DEM with an environmental impact statement that the county will be preparing in support of an upcoming district boundary amendment petition that will be filed for the landfill property. Very briefly, here is a map showing the location of the Central Maui landfill, highlighted in yellow, which is located along Pulehu Road in Punene, east of Kahului. The Central Maui landfill is the main solid waste disposal facility for Maui. The main landfill parcel is identified here on this slide as parcel 19 and is shown as number 1 on this map in the middle. This includes 40-acre Central Maui Landfill Facilities project that was approved by this commission in 2020. This allowed for the integration of solid waste management uses intended to reduce the overall amount of waste going into the landfill. Parcel 25 on the Kahului side, highlighted here as number 2 on the slide, was purchased by the county to allow for future expansion opportunities of the Central Maui landfill. In addition, the county is in the process of acquiring parcel 20, which is identified, the smaller parcel on this slide as number 3, through a condemnation action for use as a preferred site, the preferred site for the permanent Lahaina wildfire debris disposal project. This site is shown as number 3 on this slide. In terms of background, and as summarized on this next slide, the landfill is authorized through both state and county special use permits that have been issued and amended over the years since the initial establishment of the landfill in the late 1980s. These special permits are currently valid until the end of October 2028. The most recent amendment was, as mentioned earlier, in opening comments, a 4th amendment to special permit SP 97-390 in 2020 to incorporate the 40-acre Central Maui landfill facilities project that I mentioned earlier. This added 40 acres adjacent to the landfill to allow for opportunities for DEM to consolidate solid waste management operations at Maui's main landfill. This project envisioned implementation of various facilities to increase the diversion of waste from landfilling, thus extending the remaining capacity of the landfill itself. These facilities included an office, abandoned vehicles area, metals processing, construction and demolition materials recovery, household hazardous waste, and electronic waste collection and storage, including warehouse storage areas, a refuse collection office, as well as parking and other maintenance areas. Also, as a housekeeping item, the Fourth Amendment to the special permit in 2020 also allowed for removal of a portion of parcel 20 from the special permit, as it was not owned by the county at that time. This slide summarizes the Fourth Amendment actions. The pink here on the slide identifies the 40-acre Central Maui landfill facilities project, and the yellow area on the right-hand side of the slide shows the portion of parcel 20 that was removed from the permit. As part of approving the Fourth Amendment to the special permit, the Land Use Commission elected to attach certain conditions relating to important agricultural lands, as well as district boundary amendment. These conditions will be the subject of today's status update report by the county. The commission added conditions numbers 19 and 21 relating to IAL, and condition number 23 that relates to the need for a DBA for the area covered by this particular special permit. For context, this map shows the approximately 22-acre portion of the 40-acre facility site that is, as of today, designated IAL, Important Agricultural Lands.
Mr. Roy, just for context, all of this land is classified agricultural, is that correct?
Thank you.
That's a yes.
Yeah, the highlighted L shape that you see on the slide there is the 40-acre piece, and it's the green area of that 40-acre piece which is designated IAL. Does that answer the question?
Even the land that's not IAL is agricultural, but you're operating with a special permit.
Oh, that's correct. Sorry if I misunderstood the question. So there are two IAL conditions in the Fourth Amendment, one relating to the designation of new IAL lands to offset the loss at the Central Maui landfill, and the other to remove the IAL designation from the 40-acre area that I showed on the earlier slide. These next slides show the verbiage of the actual conditions that LUC placed on the special permit. So condition 19 here on this slide, I'll just read very briefly. Within 1 year of approval of this Fourth Amendment, the county shall identify county-owned agricultural property of similar land properties and equivalent acreage on Maui and submit a request to have it designated IAL to compensate for the loss of the 22 acres of IAL associated with the CML facilities project. Condition 21, that the applicant shall submit a petition for declaratory ruling to the LUC to withdraw the 22 acres of IAL from the IAL designation within 1 year of LUC's decision and order for the applicant's Fourth Amendment request. So those are the two IAL conditions. Moving to the third condition, as background, during the Commission's 2020 deliberations, there were some concerns expressed about the use of special permits in the regulation of landfill support facilities, and as a result, it was decided by the Commission that the condition of approval requiring the CML to initiate a district boundary amendment process within 5 years would be included in the approval. This DBA would seek to formally change the land use designation of the special permitted area from agricultural to urban. And so this next slide shows condition 23. I'll just briefly read it. That the applicant shall commence the process to seek a district boundary amendment with the LUC for the approximately 95.659 acres of the total permitted area of the Central Maui landfill, the CML, within 5 years of the LUC's decision and order for the applicant's Fourth Amendment request. For today's meeting, as Chair mentioned at the beginning of this presentation, the county will be offering the Commission an update on the status of its work to address compliance with these three conditions. from the Fourth Amendment, as well as address any questions that the commission members may have. That concludes my presentation today. I'll now hand back to Mr. Andrew Nelson of the County of Maui's Department of Corporation Counsel for delivery of the status report. Thank you very much.
Thank you, Mr. Roy.
Thank you, Mark. This is Andrew Nelson. Now we'll proceed by reviewing conditions 19, 21, and 23, and by providing an update on DEM's efforts to comply with each. It may be helpful to refer to DEM's letter to the LUC dated June 11th. Much of the information that I'll present today is also included there. Beginning with condition 19. Condition 19 requires that the county identify county-owned agricultural property of similar land properties and equivalent acreage and submit a request to have it designated as IAL to compensate for the loss of the 22 acres of IAL associated with the CML facilities project. DEM acknowledges that it is late in complying with this condition, but has taken recent action to comply with it. On June 4th, DEM submitted a draft petition for declaratory order to designate IAL to the LUC, the OPSD, State of Hawaii Department of Agriculture, and the County of Maui Planning Department for review and comment. DEM will incorporate the input it receives into a final petition, which we plan to file in mid-July 2024. And that's all I have on this condition. Unless you have any questions before I move on.
We'll take questions at the end.
Okay, that sounds great. So moving to condition 21. This condition requires that the county submit a petition for declaratory ruling to the LUC to withdraw the 22 acres of IAL at the CML from the IAL designation. DEM again acknowledges that it is late in complying with condition 21, but has taken recent action to comply with it. On June 4th, DEM submitted a petition for a declaratory order to remove important agricultural lands designation to the LUC, the OPSD, State of Hawaii Department of Agriculture, and County of Maui Planning Department for review and comment. And again, DEM will incorporate the input it receives into a final petition, which we plan to file in mid-July 2024. Okay, so moving now to condition 23. This condition requires that the County of Maui commence the process to seek a district boundary amendment with the LUC for the approximately 95.659 acres of the total permitted area of the CML within 5 years of the DNO for the Fourth Amendment. DEM provided an update on this condition in its 2023 annual report. In the LUC's January 31st, 2024 letter scheduling this hearing, it requested additional information on the progress of technical studies and the environmental impact statement associated with the DBA. As noted in DEM's 2023 annual report, the county is working with planning consultant Munikio and Haraga and engineering consultant A. Murr Inc. on the EIS and DBA application processes. Since the LUC's August 2020 adoption of the DNO for the Fourth Amendment, DEM's plans for the future of the landfill have changed. One aspect of that change is the properties and areas comprising the landfill. In late 2020, the County of Maui purchased approximately 59 acres of land to the north of the existing CML area from Alexander and Baldwin Inc. DEM and the county also continued efforts to acquire an approximately 20-acre parcel located to the south of the existing CML area from a private party. Those efforts have proved unsuccessful. And perhaps most significantly, the August 8, 2024 Maui wildfire disaster and subsequent recovery efforts have required DEM to rapidly shift plans for the CML, which serves a critical role as the island's major municipal solid waste landfill. In response to overwhelming public support for the CML to serve as the permanent disposal site for the wildfire disaster debris, the county initiated a condemnation action to obtain the approximately 20-acre parcel located to the south of the existing CML. Earlier this month, the County of Maui filed a motion for an order of possession of the subject property. The county anticipates that the court will rule on that motion at some point next month. DEM urgently requires possession of the subject property in order to construct the improvements necessary to begin receiving the wildfire disaster debris beginning in around January 2025. Also worth mentioning is that DEM has consulted with the State of Hawaii Department of Health Solid and Hazardous Waste Branch, its solid waste facility development regulator, regarding its plans for the wildfire disaster debris, and received comments from that agency. That guidance includes a directive for DEM to submit a solid waste facility development permit and conduct surveys and technical studies, such as cultural, historic, and archaeological survey and monitoring before receiving the wildfire disaster debris. DEM also remains in ongoing, regular contact with a number of other federal and state agencies in connection with wildfire disaster recovery efforts. Those agencies include the United States Army Corps of Engineers, FEMA, HIEMA, and the State of Hawaii Department of Health Solid Waste and Hazardous Waste Division. Following the wildfire disaster, DEM and its consultants formulated a revised site plan, which was finalized in April of this year. Given that the revised CML site plan has only recently been approved, technical studies, including traffic, flora and fauna, cultural assessment, archaeology, agricultural impact assessment, air quality and greenhouse gas emissions, noise study, hydrogeological study, and view analysis have yet to be conducted. DEM anticipates that work on those studies will begin at some point this year. Work on the preparation of an EIS will also remain ongoing. I also want to bring to the Commission's attention that DEM has published its Integrated Solid Waste Management Plan, which will guide solid waste management in the county for the next 10 years. The plan is currently in the public comment period, and a public hearing on it will be held next month. Expanding capacity at the CML and handling waste in a more sustainable fashion are important components of the plan that have been incorporated into the revised site plan for the CML. Thank you, Chair and Commissioners. That is the conclusion of our presentation.
Thank you, Mr. Nelson. Commissioners, any questions for the county? Commissioner Ohigashi.
Are you able to comment or respond to questions regarding the 11/27/2023 landfill annual report that was filed? Or have you only prepared for those 3 areas? Because I want to ask some questions about that particular filing. Is there someone in your group that can answer?
Andrew Nelson speaking. Commissioner Ohigashi, what the filing, who submitted the filing and to who?
It was a 11/27/2023 filing to Land Use Commission, the annual report
Oh,
for
right, right.
2023 that
Yeah, we can.
you guys did.
Yeah,
You did the.
in preparation for this meeting, we did focus on the 3 conditions, 19, 21, and 23, but we could try to answer any questions you might have
Yeah, so
regarding the others.
if you get that up in front of you, if you look at the first page, I was wondering, you say land purchase of 59 acres, but it doesn't say anything about I'm not sure what it's saying. It doesn't say anything about what acres or anything. It was just, so can you explain to me what that meant? Because I'm not a smart guy, so when I read something.
Sure.
Yeah, it says land purchase 59 acres. On June 3rd, 2022, scientific consultants asked State Historic Preservation for concurrence on the archaeology for this additional property as CML. I'm just wondering, what 59 acres are we talking about? Is this the one that you guys bought in 2020? It's just standing alone, so I was just wondering what it meant.
Andrew Nelson, sure thing. In the exhibit that we've pulled up from our earlier presentation, the 59 acres is displayed as item 2.
Okay, so if I count that 59 acres plus the 96 that we talked about in the original DNO, and plus the 20, it doesn't reach 259 that you had listed in here in your response that you just went through. It says that but all areas combined in CML approximately 259 acres. I was wondering, how does that jive? So that's how I link this one and that.
Got it. I believe that that larger number is the sum of items 1, 2, and 3.
Well, one is 59, or one is 96, right?
Yep,
Right? And
that's
the
a good question.
Two is the 59, and 3 is the 20 acres. So, I didn't major in math, but that tells me it's far below 259.
Right.
We got
Could I ask,
100 acres missing here.
Could I ask Mark Roy, our planning
Sure.
consultant, to comment?
Thank you, Commissioner, for the question. I don't have specific acreages in front of me this morning, but my understanding is that the 259, 260 acre number that Commissioner is referencing incorporates both the 97 special permit area, the 59 acres that the county purchased, the 20 acres that they are currently under condemnation action for, plus the area of the other special permit that governs the landfill from the 80s. I think that's where the difference in the acreage comes into play.
Okay, so we're talking about one other space. Can you identify that area that you're talking about that would be? The
Sure.
other 90 some odd acres,
86.
86 acres.
Yeah, it's approximately on this graphic that's shown on the presentation on the screen right now. The area identified by number 1 includes both of those special permitted areas. And I believe that earlier special permit largely governs the area that falls closer to the HC&D quarrying area that you see on the top side.
Are all 259 acres owned or possibly or to be owned by the county of Maui? I mean, I'm just concerned about that additional area. Are those owned by the county of Maui?
Thank you, Commissioner. Andrew Nelson. Of the 259 acres, it's only the approximately 20 acre parcel designated as item 3 that is not owned by the county currently and is the subject of the ongoing litigation.
And the reason why I'm asking is that the 59 acres that you acquired, is that in IAL designated area?
Yes.
Okay, so you're gonna have to deal with that, right? Okay.
Yes. Thank you
All
for
right.
that.
No, that's what I understand that that you want to deal with.
And I think that just to explain our intent, we wanted to comply with conditions 19 and 21, recognizing that we are late in complying with those. We wanted to address those as quickly as we could, and also in that process, get a better understanding for how we will also be addressing that additional IAL acreage.
Okay, going back to this filing of 2023, under condition 14, I don't have the page number 5. It says that the full compliance with the requirements, condition number 14, the full compliance with the requirements of State Department of Health for sanitary landfill shall be rendered. Right, and your report is landfill operations comply with the terms and permit number LF-0074-13 issued by the department and effective to February 23rd, 2023. This was filed in 11/27/2023. Did you get an extension to that 2023 permit? February 2nd permit? I'm just curious.
Andrew Nelson, I'm going to defer that question to Sage Kiyonaga from Department of Environmental Management.
Please state your name and your affiliation, and I'll swear you in. Okay, go now.
Thank you.
Say,
We have
wait, wait,
submitted.
wait, wait, wait.
Yes.
We're at the beginning. State your name and your position, affiliation, and then I'll swear you in.
Sage Kiyonaga, County of Maui, Civil Engineer 6.
Mr. Kiyonaga, do you swear your testimony today will be the truth?
I swear.
Please proceed.
Thank you. So we have submitted a renewal application to the State Department of Health. They are reviewing that application. And on top of that, we did submit another renewal application for the area in question that we may be kind of encroaching into a buffer area that is Phase 5B extension directly adjacent to parcel 20, the Phase 6 property. So we did submit a renewal application, and in accordance with Hawaii Administrative Rules 58.1, after 6 months, if we do not hear back from the department, I believe that we are administratively approved for permit renewal.
Oh, I just wanted to be sure.
Turn on your thing.
I wanted to be sure because of February 2023, it expired, it seemed.
Right.
And now we're talking about what we're in June 2024, so it's more than 6 months. So I was just, when I was reading that, that popped into my mind.
I think it was pretty close to a year prior to the expiration of the permit. We submitted that permit renewal application.
Okay. So technically, you believe it's been approved?
We are administratively approved. Yes, sir.
Okay. Might be good to put that into your reports in the future.
Yeah. Apologies. We'll try and be more mindful of those status reports to the
And
commission.
And
Department of Health Solid and Hazardous Waste Branch would be a good authority to confirm what I'm saying here.
are you guys having trouble trying to remove the IAL designation of the 20 somewhat acres that you filed for? Is there a problem going on procedurally or anything that you can tell us?
Andrew Nelson, we, recognize that we're late in complying with that condition. We have submitted the draft petitions and anticipate that the final ones will be filed in mid-July. We did receive a suggestion that we might consult with OPSD, Department of Agriculture, and of course, we did consult with our own planning department and incorporate those comments into a final petition. So that is the reason why that final petition hasn't been filed.
Okay. And the 59 acres, you plan to also remove it from IAL designation, right?
Yes.
Okay. Now, this might be not a question that you can answer, but my understanding is that when AMB went in for this IAL designation, what they did was they said, okay, we're going to designate under the statute 1/2 of our lands, or about 50% of our lands into IAL. That way, it prevents the county from coming in to designate IAL. That's what the statute says. Okay. That's one of the reasons why they added to that. They had some tax benefits that they could apply for. They had a higher, so their other lands became more available for urbanization. Okay. So what if by taking out the 70, 80 acres, it falls below the original 50% designation to NB. Would NB then not be able to prevent the county from designating IL, assuming that the county desires to do so, given the fact that Oahu tried and miserably failed, but that's my question about this, the operation of this statute. The statute involves the balancing of the county's interference in designating IL and the landowner's right to say, okay, I'm gonna designate before you and I'm gonna go 50%. If I go lower than 50%, the county still can designate IL all over the place. They can come in and designate on my property. So I'm just pointing that out to you that that the thought of that. The second thing is that the IL statute only requires a 6-vote majority on the land use commission. It doesn't, it's like a boundary amendment. It requires a 6-vote supermajority on it. That's what the IL statute requires, gives us. So what I am suggesting is that if the county comes forward with its boundary amendment for the purposes of determining that area as urban, and however you want to use it in the future, to determine that, is that meets the IL hurdle. In other words, all you need is 6 votes to change IL lands into urban lands. And it's the same as doing a DBA. Okay. I have one other comment that I wanted to make, is that, or question, are you going to develop the 20 acres under the governor's EO, executive order, thereby necessitating not needing any kind of special permit or anything like that to develop that?
Thank you for that question, Andrew Nelson. Due to the fairly firm deadline that we face to begin moving the wildfire disaster debris from the temporary disposal site at Oluwalu to the permanent disposal site at the CML, we do anticipate needing to proceed under the governor's EP. Yes. Yes, emergency proclamation.
So that's your intent. That's your intent, right?
Yes, and again, that would only occur in very close collaboration with our, various regulators, including.
I'm not, don't worry, that's not the drift of my question. My question is mostly this, is that once the EP ends, what designation are we going to put on that piece of property? It's not covered by the special permit. Unless you urbanize it, it may not be covered under that. But once the EP ends, it's going to have a time when the EP has to end, right? And you have this property filled with contaminated dirt from Lahaina. What restrictions does, what designation will it be, and how is the public going to feel that there are specific restrictions on the use of that property that will carry on and run with the property? Because the EP gives you a carte blanche to put on property what you want to put on it. And you can bypass certain things, but what things will be used to make sure that that property is properly designated in the future?
Thank you for that question, Andrew Nelson. Our intent is to include that 20-acre property in the DBA district boundary amendment. That's the subject of condition 23, along with the rest of the CML.
Intermittently, is the county going to agree that the terms of the special permit that you now have would also apply or be written into that area so that there's some environmental protections concerning that area? You don't, if you're not empowered to answer it, my advice to you is say, I don't have the answer to that, Mr. Ohigashi. Maybe we have to have a discussion with the department head and the.
Thank
the
you,
corporate
Commissioner.
counsel.
Your advice is very well taken, and that's the position that I'll take as well.
Yeah, because I'm almost Paul with this gig, so I'm not gonna try and trap you with it. Okay, I. And my other question is, I read from news reports, and maybe I'm wrong or anything like that, is that there's a controversy as to whether or not you're going to need all 20 acres for the debris removal storage, and there will be additional space that will be used for. The question is, the county Maui wants to use it for additional space for the what is for future use for waste disposal. The question that I have is really is that is the EP going to cover all of the 20 or only the 5 or the area that is necessary? If
Thank you
don't.
for that question, Andrew Nelson. I do not have an answer to that specific question, but I will acknowledge that what you stated is consistent with our intent in terms of initially disposing of the wildfire debris, and then later using the balance of the remaining capacity for municipal solid waste, ongoing use.
And one of the questions that I is that you're starting the process to do an EIS. Is that right? For that area.
Yes.
Is that the 259 acres? Or is that what you guys are doing?
Yes, that's the current intent.
Okay, and if you, who will be the receiving agency? If you,
DEM has been in the past.
DEM will be the receiving. Is there a problem with the Energia case that you may face?
I am aware of that recent decision. I would need to look into that question further to answer.
I just was curious about that. That was one of the things that I had on my mind. The last question, the last is more of a comment, is that when I was here in 2020 and I sort of insisted on the boundary amendment, and my thing is that it was an industrial use being proposed for that area. But more and more I'm looking at things that are happening in the state that special use permits are being used for example, like Waimanalo Gulch, that it becomes a political nightmare. I think that we have an area here that is going to be used for designated waste disposal. It's going to be used for the dirt, the contaminated dirt that probably will make that whole area not usable for agriculture or significant recreation for some time until it's determined that it's safe. right? And more, if you keep a special permit, you run into people like myself, sit on these boards and commission who have listened to the public and want to try and get a public. I think that the proper people to determine the use of that area is probably County for Waste Disposal. Given the nature of that area, you know, I've been there how many times in the past, but given that nature of that area, it seems to me that a boundary amendment there and will be the best solution. You put it under your control. If you folks own the property, you put it all under your control. You have the council designate what its use can be. And then we have a permanent facility for years to come. And maybe until we develop technology that will eventually not require, have that kind of waste disposal. So that's my only comment. And it's sort of like saying, yeah, maybe I was right for the wrong reasons way back when. Okay. But that's my comment. Thank you.
Thank you, Commissioner Higashi. Appreciate your 17 final questions. I do remember in 2023, and there was strong encouragement from this commission for you to pursue that DBA for this site. I just have a couple of questions for clarification. I think you covered it, but I want to make sure we don't have any confusion. And then I'll open it back up to the commissioners for questions. So there's 260 or 259, 260 acres that one way or another constitutes the area that you intend to use for waste management. Is that correct?
Yes, that area includes all of the CML, including portions that are no longer active.
Correct. So of that 260 acres, I understand that 79 are currently IAL. Is that correct?
I don't have that particular figure handy, but that does that's also consistent with my understanding.
Was 20 plus the 59 that you mentioned in your earlier testimony today, 79. And it's your intent to remove all 79 from IAL designation. Is that correct?
Yes,
And that you have started the process on 22 of the, it might be 20 or 22 of the 79 acres. Is that correct?
yes, we will be filing a petition in mid-July. Right now, we are just seeking comment.
So that petition that you forecast to file in mid-July, will it include the 59 acres or only the 22?
No, it would not include the 59 acres. Our intent is to get through that initial petition process, which of course would also, it's two petitions. One is to remove and one is to designate in county-owned agricultural land in Kula. And so our intent is to comply with those conditions and then to do another set of petitions to address that remaining IAL acreage.
The swap. Yeah, so
Yes.
so for the first 22, could you describe have you identified the land that you intend to move into IAL? Just in general, I know you're not petitioning today.
Yes, it is an approximately 30-acre parcel located in the Kula Ag Park, which is an active agricultural use.
Okay. in the future, into IAL?
No, we have not, but we do, also intend for that to be in the Kula Ag Park.
Okay. So I'm going to add a little refresh from my memory that goes along with Commissioner Ohigashi. And the commission at the time gave very strong encouragement to a DBA for this. We thought it made a lot of sense for you to centralize the waste management operations and to include industrial technology as part of that entire operation. And for it to have a sense of long-term or permanence to it, which is not really a perfect fit for a special use permit on agricultural land. And that was the basis why you were strongly encouraged to pursue the DBA. And we echo that again today, that it does look like that makes the most sense for you in the long run. And it just makes common sense to me personally, right? So those are my questions of clarification. Let me reopen it to commissioners for any other questions they have on your presentation. Commissioner Carsmith.
Thank you, Chair. That helped. I've been trying to understand what the reasoning is behind wanting them to do a DBA as opposed to continuing their special permit. So what you just said helps a little bit. I'm still not sure whether I totally understand the reasoning there, but can you clarify? I think I heard you say that the 20 acres is in litigation. Can you explain a little bit more about that, please?
Thank you, Commissioner. Andrew Nelson. Yes, that's correct. The 20 acres is currently subject to a condemnation action, eminent domain, which has been, the complaint was filed by the County of Maui in state court. It was then removed by the landowner into federal court. And that's where the litigation is currently situated.
Okay, thank you. I thought you were referring to something else, but I'm good for now, Chair. Thank you.
So the 20 acres that's in litigation, that's not the 22 that's IEL that was identified previously. The 22 that was identified previously is part of the 96. Is that correct?
That is correct. The IAL is situated more towards the north. And then the 20-acre parcel is at the bottom, the very south.
Understood. Thank you. Commissioners? Mr. Lee?
Thank you, Chair. For the petitioner, you mentioned that you most likely will be taking advantage of the governor's emergency proclamation provisions. Can you tell me which provisions you would likely be taking? For example, some of them are, well, you mentioned you were going to do an EIS, but that is a potential exemption in the emergency proclamation. Also, hiring procedures, prevailing wage, procurement, historic preservation. Do you have an idea which ones of those exemptions in the emergency proclamation you might be using?
Thank you for that question, Andrew Nelson. I am not prepared to identify, with specificity each of the HRS chapters that we are looking to, be exempted under the EP. However, it is, obviously something that we are, that we've researched and are working on. I just don't have a firm position to offer today.
It seems like you guys are taking Commissioner Ohigashi's recommendation to say you don't know very seriously. Thank you, Chair.
You don't know, you don't know. Commissioners?
We're gonna
Okay, we'll move on to hear from the Department of Planning, from the county and from the state, and then petitioner will be given another opportunity to provide additional comments after that. So let me turn now to the County Planning Department.
First Deputy Mimi Desjardins, thank you, Chair. The Planning Department doesn't have any comments in addition to the presentation and the question and answers, but we really appreciate the input from you folks because as you can tell, this is a moving target. I will make one comment very briefly on the use of any emergency proclamation, and that is that as we move further away from the epicenter of any disaster, we are constantly evaluating what do we need to pay attention to and take advantage of, and what can we do to not depend so directly on that emergency proclamation, because it's qualified by actions that would impede our immediate response to disaster. So as we get further into the recovery process, but I will say that when we do rely on an emergency proclamation, we always attempt our cleanup at the other end, because we certainly don't want to not comply. But there are times where these proclamations have made the difference between us being able to meet the community's needs and not. So that's sort of how we look at whether it's the mayor's or the governor's proclamation. So I hope that gives you some sense of comfort that we're not completely carte blanche, violating laws or ignoring laws, but we are trying to balance. Thank you.
Does that conclude your remarks?
Yes, sir. Thank you.
Okay, commissioners, any questions for County of Maui? No? Okay, thank you very much. OPSD, please make your presentation.
Thank you. Allison Kato, Office of Planning and Sustainable Development. DM has acknowledged their land compliance, but they've submitted the necessary documents to remedy this. We understand it's being treated as a draft for now, and we've received them, and OPSD can provide initial comments to the county to incorporate in its final submittal. Regarding concerns from state agencies, the Department of Health provided comments with respect to conditions 4 and 14 having to do with the DOH permit to operate the landfill. They said that while the county is currently landfilling in a portion of the property not currently permitted to accept waste, they've submitted a permit modification to DOH to address this. I understand there's some sort of rate of entry issue, but DOH understands county is working to fix that, so they don't have any immediate concerns with this. Sorry, 1 second. Sorry, we wanted to ask just to confirm about the IAL that was mentioned, the 59 acres. So I guess
Why don't you ask it in the form of a rhetorical question, and then maybe the commissioners could take it up from there? Or express your concern, or
so did you say that the 59 acres are IAL?
that's what was put on, that's what was said.
Okay. And that's the L shape that was on the map,
That's
the land purchase.
my interpretation, that's the inland parcel. Can we put that map back up that clearly shows, could I ask the petitioner to put the map up? It clearly shows the 59 acres, just for clarification.
Mhm.
Mr. Roy, could you speak to which parcel is the 59?
Yeah, thank you for the question. Mark Roy with Munikio Hiraga. So the graphic that we're showing that outlines the entirety of the Central Maui landfill on 1 and 2 here, that's currently owned by the County of Maui. Number 2, identifies the 59-acre piece that was purchased from AMB.
And that's entirely IAL.
That is IAL, yes.
Thank you. OPSD has no further comments on the presentation.
Thank you. Commissioners, any questions or comments to OPSD? Commissioner Ohigashi?
So you heard my thoughts that I did before. Assuming that the 59 acres and the 22 or 20 acre parcels are removed from IAL. Does that,
2022,
yeah, does that mean that AMB may have fallen below the 50% requirement? And would that mean then that the county can designate any part of AMB lands IAL if they desire to do so?
That's a good question.
We'd have to check the docket. So we can't answer that this time.
What is the purpose then of having it removed and supplemented or removed and replaced? Is there a purpose in that, that the OPSD, I think it was your proposal originally in 2020 that resulted in this swap, this idea. So if I remember correctly, what is the purpose of having those 59 or those 22 acres replaced as IL?
I believe, and I wasn't part of it at the time, but I believe it was, the reasoning is because it did not appear appropriate to have IAL be landfill. So because part of the expansion area was IAL, the thought was to take that out of IAL and then replace it with lands elsewhere.
Would OPSD also recommend, if they do a boundary amendment for the 59 acres, a replacement of that 59 acres from IAL?
I mean, along the same reasoning, that would probably be correct.
So. When you remember what I recited about IAL designation and what does it mean? Is that basically your understanding too? That if you designate 50% and that leaves your other lands alone and you're free to urbanize it, it prevents the county from coming in and urbanizing or IAL designating those lands? Is that what?
Sorry, just 1 second. I'm not entirely clear on what the question is.
The question, do you understand the question?
Can my client answer it?
Yeah,
Respond to
you
this?
can. Anybody can.
He needs to be sworn in.
Sure. Please state your name and affiliation for the record, and I'll swear you in.
Aaron Sedergawa, Office of Planning and Sustainable Development.
Mr. Santagata, do you swear your testimony today be the truth?
I do.
Please proceed.
Okay. Yes, Commissioner Higashi, I understand your question. So just to put it in context and to confirm that I understand it, when a private party comes in for IO designation, they are required to provide at least 51% of the land that they own in their parcel to be designated IAL. In order to benefit from the benefits of IL, such as tax breaks and so on. So your question is, if this 59 acres, in addition to the 22, well, if you've taken out 22 acres as part of one of the conditions of the renewal, and then now you're gonna take another 59 acres out when the overall landfill becomes in a DBA to urban, does that impact the original IAL designation for A and B land? And the answer is, I'm not sure because I'm not familiar with the original docket. We'd have to go back and see how much land in total A and B entered into IAL and how much land that they kept out. I would think that if it does affect the ratio, then whatever benefits they enjoy would be in jeopardy.
And the county of Maui, are they able to partake of this 51% designation? If county-owned lands, they say, well, we want to do 51%. Are they eligible, or is it only for private entities?
I don't get that. Okay, so you're asking if the county is subject to, if the county designates land, asks to designate
Their
land.
own land, their own land.
Yeah, I know, their own land as IAL, are they bound to provide 51%? And that's what, I don't think so. Well, let me put it this way. If they're doing it under the basis of a countywide IAL, then no.
Okay, so
But if they're doing it as an individual parcel, I would, that's a question, that's a good question.
so IAL lands, I'm just trying to get a point across. The statute appears to be focused upon not necessarily preserving important agricultural land, but providing a mechanism for private landowners to say, I'm going to put this in IAL, but I can develop the rest of this in the future. That's the purpose of the statute that I can see. So my real question is, do they even have to substitute? Because what they're planning on substituting, my understanding, is a Kula Ag Park, which will never be subject to development, which will always be agricultural lands. And it would be just stupid for the county itself to say, oh, we're going to designate this IAL because we own the land and we want to substitute it and say that. But it's built for agriculture. That's the purpose of that park. So rather than playing all these games, my understanding of the statute is that it requires 6 votes. And if we give them 6 votes to do a boundary amendment, we can take it out of IAL lands and we can take it out of, and we can change the boundary. But it's up to the future land use commission to make that determination, not me. But that's my understanding of the law. So I don't see the purpose, and I've never seen practically the purpose of substituting one property for another, unless NB is going to give us 80 more acres for their land to put back into the agriculture. But to put a county's agricultural park into an IL designation, it seems to be stupid because it's already going to be used for agriculture for as long as we know. That's just a practical thought that I have. Okay.
So let me add a question on a comment. I think that the logic to replace the area on a like for like basis for what's removed from IL to new land to IL was not driven to just go find some other agricultural land, but might actually be tied to this 51% requirement from where that land was coming from. So I don't know if you can comment on that, but I think Commissioner Oigahi's first question is, if, and this is hypothetical, if the removal of the 22 plus 59 acres from IAL affects the 51% number so that becomes less than 51%, is it your perspective that other land owned by that same landowner would have to be the source of replacement so that it could go back above 51%?
I'm not sure I can speak that clearly without looking at this more, but that would seem to make sense, although I guess when you're saying what is the purpose of designating other land as IAL, my understanding is that the purpose of IAL is to basically designate lands that are appropriate to preserve and that will receive benefits from IAL designation. So if you're saying why should an ag park be designated as IAL, it seems to me that if we lose IAL lands, it would make sense to have it replaced with additional lands to be preserved for agriculture as IAL that could receive these benefits. Just
Yeah, I think there's a
my
caution
understanding generally.
to the county that when you identify the replacement 22 acres or replacement 59 acres, that you don't end up in a quandary because of the 51% rule for the original land that was designated. Does that make sense?
Andrew Nelson, I am not familiar with the 51% rule. But, we would have to look into that.
Yeah, I think the commission today, Commissioner Ohigashi and myself, I just throwing a caution out there that it may be more complicated than just go finding land in the ag part. It's already agriculture and say, well, we'll just designate that IAL. There might be other complications and it's worth a little more research.
Thank you.
Ms. Cato, does that conclude your remarks?
Yes, thank you.
Okay, commissioners, any further questions for Ms. Cato? Okay, so I've heard that our lunch wagon has been delayed. I think, or is it here? Oh, he made it. Thank you. So, commissioners, what's your pleasure? We could take a brief, recess for bio breaks and come back and deliberate and finish this, this agenda item. Or we could take lunch now. What is your pleasure? Well, there was one person that spoke up. I think it was, so we're going to take a 30-minute break for lunch. It's now 12:23. We'll resume at, I'm gonna take 27 minutes. We'll resume at 1 o'clock. All right. Back on the record, it's 1 o'clock. So where we left off was with the presentation and comments by commissioners to OPSD. So we've heard from OPSD and the County Planning Department. So petitioner, do you have any further comments, rebuttal, or questions at this time based on what you've heard?
Thank you, Chair. Andrew Nelson, no further comment.
Thank you. Commissioners, any further final questions or comments for the parties?
I just have a comment before we go.
Commissioner Ohigashi.
If you intend to include the 20 acres in any filing, the 20 acres that you're seeking to under condemnation, in any filing before the commission, it should be, the commission normally requires that the owners and all ownership interests be part of the petition. So it would behoove you to get specific authority within any federal court order that you may eventually, hopefully get to file, to include that. That's just,
It, good. Ms. Kwan, final call for public testimony. As any members of the public wish to provide new and additional testimony on the status and progress of SP 97-390?
No, Mr. Chair.
Thank you, Ms. Kwan. Commissioners, this has been a status report, and we're not required to make any motion or take any action at this time. If no action is taken, the requirement of continued annual status reports will remain. However, if the commission feels that its concerns have not been adequately addressed, based on the comments and responses provided by the petitioner, the chair will entertain a motion that either the petitioner status report has not sufficiently addressed the commission's concerns, and that further meetings or status updates are necessary to provide the opportunity to do so at future dates to be determined by LUC staff, or that there is reason to believe that the petitioner will not adhere to the conditions set forth in the DNO and request that staff move forward with a formal order to show cause proceedings. Any discussions on this further? Commissioner Carsmith?
Thank you, Chair. I do have a question for the petitioner about condition 23 and the deadline for the DBA. I'm not sure whether that's the filing for the DBA or the approval.
I think the language was to commence the DBA
Process.
by
Okay.
5 years. Yeah.
And that's 2025. Do we know when in 2025 is that?
So it's by October 31st, 2025, they have to commence the process to pursue district
Okay.
boundary amendment.
So my question is that reasonable? Do you plan to be able to meet that deadline?
Thank you, Andrew Nelson. Yeah, it is our intent to, we are targeting that deadline. Obviously, there are a number of technical studies that will need to be completed before then. But again, we do intend to meet the condition.
Okay. So I've learned a few things today, which is always good. So now I understand that the special permits in ag zone districts or ag designated districts, when the permit is POW, that the property needs to be returned to its original use and be able to be used for ag, right? And I think that that's been made clear to me, that because it won't be able to be returned to ag, and because you plan to use it in perpetuity, or that's estimated. Is that correct?
Thank you, Andrew Nelson. I do know that in connection with the Fourth Amendment proceedings, the potential for remediation of the areas that were formerly landfill into some sort of agricultural use was at least considered. I think that with respect to the more permanent facilities, related to recycling, and I think other kind of waste handling, those would not be returned to agriculture. And so I think that that was part of the rationale that the commission, that at least some of the commission members had, to recommend a DBA approach as opposed to continuing with special permits.
Okay, so that's one of your conditions for you to submit for a DBA. So why would you be bothering with the important ag land swaps? Removing the designation, finding replacement properties. If your plan is to proceed soon with the DBA application, why would you bother going through these other steps?
Probably the main reason is to comply with the conditions of the DNO as written. As opposed to seeking a modification at this point.
It wouldn't make more sense for you to ask for them to be removed or to seek modification, as you put it?
Think that may be something that we consider, especially once the petitions have been formally filed in mid-July, and we receive the commission's feedback on those petitions.
Are you referring to the removal of the AIA, the important ag lands, when you say petitions?
Yes, the petition to designate approximately 30 acres at the Kula Ag Park, and then the separate petition to remove approximately 22 acres at the CML from IAL designation.
Okay, so you feel you still need to do those even if you're going to go forward with the DBA?
Yes.
Okay, thank you.
Thank you, Commissioner. Anything further, Commissioner? Is there any further discussion among us on this matter before we go into deliberation? Hearing none. Commissioners, what is your pleasure? Again, I'm just going to read this again, just so you know what our options are. Our options are that we consider the status report to be adequate and that we're satisfied with the petitioner pursuing their work as they described it to us and including annual reports as specified. Or we may take a more specific action to require additional information updates or a declaratory order to proceed with a show cause. So what's your pleasure? Commissioner Ohigashi.
Move that we accept the status report and that we await for the July filings.
So you're satisfied with the adequacy of today's presentation?
I can comment on that.
Okay, so the motion is to, I'm sorry, Commissioner, could you restate the motion?
To accept the status report.
Thank you. Do I have a second to this motion? Commissioner Carsmith seconds the motion. Commissioner Ohigashi, you want to speak to your motion?
Yeah, even though there are some inadequacies, I think because of the lateness in trying to resolve some of the issues by the county, I think that they've indicated their course of action in this matter. And I think that they've represented that they will be completing their petition to be filed, at least their petition to be filed, so the issues can be discussed by this commission within a reasonable time from this date. And the indication or the statements of the reliance that they're giving me is in July. And I tend to think that they would be complying with it because after this status conference was scheduled, they seem to have moved quickly in trying to resolve some of the basic issues that they are. The rest of the comments that I've made during this hearing is merely my own opinion as to about the IAL process and my feelings about it. And I think that's up to you folks and this commission to work out this. I would note that initially, I think I voted against this, but that's neither here nor there.
Thank you. Commissioner Carr Smith, you want to speak to your second?
I don't really have much to add. I guess the only thing would be is if they don't have anything for us in July, we need an update of some sort, right?
Yeah, they'll have an annual, do we know the date the next annual report is due? October of this year, so that's only 3-4 months hence. So we'll be looking for an update in that October timeframe that will give us more detail on their plans for the subsequent year. Anybody else want to comment on the motion? I will just comment that I felt that the progress has been restarted and is being made. It's a complex situation. I'm satisfied that with the adequacy of your reporting today, and I thank you for it. And I will be supporting the motion. So, Mr. Orndecker, please take a roll call on the motion.
Thank you, Mr. Chair. The motion is to accept the current status report. Commissioner Ohigashi,
Aye.
Commissioner Carr Smith,
Aye.
Commissioner Atta, Commissioner Kahele, Commissioner Kamakeo Hello,
Aye.
Commissioner Lee,
Aye.
Commissioner Yamane,
Aye.
Chair Giovanni.
Aye,
Thank you, Mr. Chair. The motion passes unanimously.
thank you. And thank you for your time today and your preparations for our meeting. Appreciate it. Yeah, let's take a 5-minute recess. It's 1:15. We'll reconvene at 1:20. Okay, it's 1:20, back in session. Our fifth order of business is the commissioner's discussion on the executive officer contract terms and salary adjustment. LUC staff has informed me that there's no public testimony written has been received regarding this agenda item. Ms. Kwan, are there any members of the public that wish to provide testimony?
No, Mr. Chair.
Thank you. So I'm going to provide a little bit of background. So the performance evaluation was facilitated by Commissioner Ohigashi and was discussed at our last meeting. Commissioner Ohigashi sent commissioners a performance evaluation form that they individually filled out.
Chair,
Chair,
I think
we're missing one commissioner.
Where'd he go? Oh,
he's coming right now.
okay, well, I will start over when he gets here. Okay, we're going to proceed on the fifth order of business for today, which is the performance evaluation and contract term review for our executive officer. And in review, looking back at our last meeting and prior to that, Commissioner Ohigashi facilitated a performance evaluation, a completion of a form that was done by each commissioner. It was also a self-evaluation provided by the executive officer. That was taken into account and we went into executive session in which the performance evaluations were compiled. Subsequent to that meeting, I issued a summary of what happened in that executive session. That's a note, an email that I drafted on May 8th, 2024, a copy of which was directed to the executive officer. But in summary, I've handed, to facilitate today's meeting, I've made copies of that email, and Ms. Steed has acknowledged that it was be appropriate that I could hand that out to you for reference purposes. But in general, it shows his compiled or average readings from among the commissioners in 8 different categories and with an overall performance evaluation and who this meeting was attended by. It was then decided that we would look to today's meeting to finalize the process. So what I envision is a 2-step process. The first step, I will entertain a motion from the commissioners to go into executive session. And while in executive session, we will further discuss the details of the executive officer's performance evaluation, as well as any personnel or privacy matters that we want to be able to discuss in private. Following that, we'll end the executive session and proceed back to public session. And in public session, we will look to deliberate and make a decision on any recommendation on a salary adjustment based on the performance evaluation or any other terms that might be in the employment contract. So does anybody have any questions or comments on what I'm proposing in terms of a 2-step process? Seeing none, do I have a motion to go into executive session?
So moved.
Who was that? Commissioner Kamikalohele,
Second.
seconded by Commissioner Yamane. So we will now go into executive session.
Chair, I think you have to also say who you want to be in the executive session.
Want the commissioners and the deputy attorney general, and that's it. Yeah. Was that the intent of the motion there? Yeah, okay. So we have a motion to go into executive session that would be exclusive to the commissioners and the deputy attorney general. And we have a second to that motion, and I'd like to take a roll call vote on that. Mr. Arndaker, can you take it? I can voice vote. All in favor, say aye. Any opposed? Okay, now can we go on exec? Now we go. Okay. We're going back on the record in public session. Could I ask everyone to take their seats? Thank you. So we've just concluded executive session, and I'd like to put on the record that during executive session, it was attended by all 8 of our current commissioners and also Deputy Attorney General Miranda Steed. So that's who was present in executive session.
Chair, I think you meant all 9 commissioners.
We don't have 9, we have
Oh,
8.
that's right. Gary's presence is still felt for me, I guess.
Yeah, I feel Gary, but he wasn't here yet. And Commissioner Uu will be with us next month. Anyway, 8 is the correct number. During executive session, we just previewed for reference purposes the substance of our survey that was facilitated by Commissioner Ohigashi and discussed in our last meeting. And just for reference, that had Mr. Orendanker, our executive director, had an overall performance rating by our own self-defined metrics of 3.71. And for reference, 3.0 is equivalent to meets expectations. So Mr. Orendenker, in his performance the past year, exceeded our expectations in his performance. And that's the consensus of that's the compilation and the numerical average that was done by the survey that was conducted of all commissioners, again excluding Commissioner Okuda, who had recused himself. We also had an opportunity for commissioners to express any questions they had or concerns they have about the process and how it works and where we go from here. And that was a good discussion we had. Most of that will be retained in private. So where we go from here is that we want to deliberate as a commission in terms of his specific salary adjustment that would be commensurate with his performance evaluation that we have completed. So at this time, the chair will entertain a motion from any commissioner regarding a recommendation for a salary adjustment for Mr. Orendenker, our executive officer. And that recommendation would go to the state for implementation. We don't have the independent authority to execute and change the salary.
Chair, I'd like to make a motion.
Commissioner Lee.
Thank you for the good discussions that we had. I think it was very good to have opinions expressed and people listening to each other's views, whether we agree with them or not, or have our own views. But and I appreciate that I had a chance to talk with the executive officer, and that we had we did. I feel we did some due diligence this year and looking at things, and I thank you for that. I would like to make a motion that the executive officer have a salary increase of at least 4.5%, or the bargaining unit 13 increase, whichever is higher.
Thank you. Do I have a second to that motion? Seconded by Commissioner Atta. So my understanding, and this is just through my own version of due diligence, is that the bargaining unit increases 4.56%. So with your motion, since that's slightly higher than 4.5, your motion in effect is a recommendation of 4.56%.
Yes, whichever is higher. So yes, that would be effectively.
Yeah, okay. Do you want to speak to your motion?
Sure. Thank you, Chair. I think there was some good discussion had, and I think that going forward, because of these discussions, things will be even better. Because it's good to have frank discussions. I mean, we're all here for the same thing. You know, Mr. Orendenker has a difficult job, and I think that we can help him do his job by setting clear expectations. And I think we've all seen with some of the comments that have been made that things have improved in a lot of ways as far as information and communication. And I think that will continue. You know, I think we all have a part to do in making the Land Use Commission as good as it can be. And I appreciate that Mr. Orendenker has been receptive to input and that he has responded positively to that. So I think that, you know, I appreciate everyone putting up with me, actually. So thank you very much.
We all have to put up with you, Mr. Lee, and we all enjoy it. Commissioner Atta, would you like to speak to your second? In the microphone, please.
Just the idea of having going either or. I thought that was a novel way of looking at that, and going with Unit 13 thing. It makes sense, and I've been member of city and state government before, and then I know how the Unit 13 works. So Yeah, I think that's a good thing.
Thank you. Anybody else? You want to speak? Okay, so, just to clarify numbers, and these are to be verified, but I think they're accurate. Current salary, 154,176. Annual salary with this adjustment of 4.56, it goes to 161,206. That's in the ballpark if it's not the exact numbers. Does that sound about right? Yeah, sounds about right. So no further discussion. We'll take I would like a roll call vote on this. Can you execute for me?
Thank you, Mr. Chair. I'm not sure. Is it okay if I do this? Okay. Thank you, Mr. Chair.
Just get the numbers right.
The motion is to have the executive officer have a salary increase of 4.5%, or the bargaining unit increase, which is, we think, approximately 4.56%, whichever is higher. Commissioner Lee,
Aye.
Commissioner Atta,
Aye.
Commissioner Yamane,
Aye.
Commissioner Ohigashi. Commissioner Kamakeo Hello,
Aye.
Commissioner Kaheli,
Aye.
Commissioner Carr Smith,
Aye.
Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Thank you. Okay, thank you. So the chair will, continuing with the process that we discussed in executive session. The chair would also entertain any motion regarding any other term, a recommendation regarding any other term to the employment contract with the executive officer.
Mr. Chair,
Commissioner Ogashi.
I move that we add one more year to the existing contract. Essentially roll it over for one more year till 2027. And I will explain if I get a second as to what my reasoning is. Thank you.
Do I have a second to that motion?
I will second to open the discussion.
Very good. Commissioner Ohigashi.
I'm suggesting for a one-year extension to this existing contract. It's essentially, he has 2 years left after this June and into 2026. I'm suggesting we move to 2027. After 1 year of the new commission, it'll be a 2-year contract back again, right to where we started. So I think that to give the commission and the executive director an opportunity for him to perform in a different or in accordance with the new commissioners inform the new commissioners' desires or their needs, or to meet their needs. I think that we should add another year for to give him that opportunity and certainty to do that. And essentially it'll wind up as a decision next that in 2025 as to whether or not to continue his employment contract further than the 2027 deadline. So that's my
Okay, thank you. Mr. Kamakalo, hello, you want to comment on your second?
Mahalo, Chair. I really support the idea and the concept. But the reason why I seconded to open for discussion, because there's just one clarification on the specific agenda item that we're discussing right now.
So on the agenda item 5, it says Commissioners' discussion on executive officer contract terms and salary adjustments. I just wanted to make sure that if we are to take action, because this is in fact a motion, that,
So let me put that to Ms. Steed. Would it be appropriate for this commission, based on how this item has been agendized, to actually make a recommendation on the term of the existing employment agreement or not?
It would probably be better if you,
Say what? Speak loud and clear.
it's probably better if you postpone and re-agendize with an action item.
Fair enough. So for those of you who may have not heard that interaction between the commissioner and deputy attorney general, he seconded the motion, and I'm going to paraphrase what I think you said. Okay. He seconded the motion because he wanted a discussion on the matter to get clarification for whether or not it was appropriate and advisable for this commission to make a recommendation on the term of the executive officer's employment agreement at this time relative to how this matter has been agendized. And then in a question on that issue to the deputy attorney general, the response was it would be better if we postponed it and agendized it directly.
so Mahalo Chair for the clarification, and if I may follow up with a question to our Deputy Attorney General.
Please.
Can we take action today or no?
Please speak in the microphone because it is on the record.
Would you like to ask me these questions in executive session?
If it would please the chair, I would entertain.
I think this is a legal question and it's probably best we deal with it in executive session. So
Mahalo Chair, I make the motion to enter into executive session.
do I have a second to go? All in favor of going to executive session signify by saying aye.
Aye.
Aye. Any opposed? Thank you. We're adjourned, our recess to go in exec session. Okay, it's 2:43. We're back on the recording, I believe. Is that correct? All right, so we're back in general session. We've just concluded an executive session that was attended by 8 active commissioners, as well as Deputy Attorney General Steed. And it was to address legal questions in our mind dealing with sunshine law. And we concluded that session and we're now back into regular session. And we have a motion on the floor that's been made by Commissioner Ohigashi and seconded by Commissioner Kamikela Ohele. And that motion is to extend or to recommend an extension of the executive director's employment contract by 1 year with a consideration to do something similar by the commission a year from now. Is that correct? Correct? Okay. Did you want to say anything further on your second?
Yes, Chair.
Please.
When I made the original second, it was to open discussion, and I just want to say on the record that I am comfortable in saying that I support the original motion to extend the contract a year into the year 2027, I believe.
I believe that's correct.
Okay, mahalo, Chair.
Mahalo. Anybody else want to speak? Commissioner Lee?
Chair, I understand the sentiment, but since there are going to be 3 new commissioners coming on next month, I'm not really comfortable with imposing something for almost their entire next term up until 2027 that they would be effectively operating under without their input. So I'm going to vote no.
Okay. Anybody else?
Yep.
Mr. Carsmith?
I don't agree with this either. I live in a world of contracts and Dan's got 2 more years on his contract and it seems reasonable to me for us to simply extend his contract when it's time. I don't see any reason to do it sooner.
Anybody else?
Mr. Chair,
Commissioner Imani?
I'll be supporting contract extension for the executive director. Thank you.
Thank you. Anybody else? Commissioner Kahale?
Chair, I'm supporting the motion.
Thank you. Anybody else?
Chair,
Commissioner Carr Smith?
I support the executive director. That's not what this is about at all. They're just, it seems unreasonable to extend a contract early. What has been done in the past? Executive director, if you can answer that, please.
I have had several contract extensions before the term expired, in the past. Oh, not several, a couple. It's, I don't know, it's been practice, a regular practice, so. I mean, it's not something that is outside of this commission's experience.
Thank you.
So the chair will support the motion as well. I feel, I mean, the number one thing to me is continuity, and I would like to know and feel, I don't, you may never know for sure, but I would like to feel that our executive director, whoever it may be, and in this case, Mr. Orendanker, can look forward to a tenure and give his all for that tenure. I don't want him sitting around with a year left in his contract, thinking about what he does next and having more vision to not be here than to be here. So I would support this motion for an extension. I would support a motion for a longer extension, to be honest, but I will support this motion. Anything further? Take a roll call, please.
Thank you, Mr. Chair. The motion is as stated by the chair, to add 1 more year to the existing employment contract for the executive officer.
Just like clarify, I still recommend. We don't have the ability to make that absolute decision. Do we? We can do that.
Yeah.
It's our decision.
Yeah.
Well, I thought we had to get the state HR people to.
Have to agree with the song.
I have to agree to it.
Everyone wouldn't, but I think you have to.
Yeah, no, I have to sign the extension, so.
So what's the right way to phrase this motion? What do? That we would extend an offer to the executive for a year. So the motion is to offer our executive director a 1-year extension to his existing contract, which we think will be through 2027, July 2027, June 30th, 2027. Okay? Got it?
Yep.
Okay, go ahead, roll.
Thank you, Mr. Chair. The motion is as stated. Commissioner Ohigashi,
Yes.
Commissioner Kamakeo, hello.
Yes.
Commissioner Atta,
Yes.
Commissioner Carr Smith,
No,
Commissioner Kahele,
Yes.
Commissioner Lee,
No.
Commissioner Yamane,
Yes.
Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes with 6 affirmative votes.
Thank you, and hopefully you will accept our offer.
I will accept, Mr. Chair. Thank you.
So let me give you an opportunity to speak to the commission on the actions we've just taken, if you so desire. Which was the salary adjustment and extension, if you want, if you don't want.
I just want to extend my appreciation to the commission for recognizing my work. As stated by Commissioner Lee, I strive to adjust how we handle things based on the commissioner's needs and desires, and I will continue to do so. listen. I'm very open to whatever the commissioners have to say about how things are handled, and I hope I can be as responsive as they require.
Thank you. If there's no further business to today's agenda, there is none. I declare this meeting recessed until tomorrow at 10 a.m.